Your patent sucks because your invention is obvious, part 3. My name is Steve Hansen. I've been a practicing patent attorney for over 25 years. Not only do I write patents, but I tear apart other people's patents in litigation. Hey, if you like this content, please do me a favor and like, follow, and share. This is the third of a 3-part video series on how to protect your patent applications and patents from an obviousness challenge. Okay, so this video is the punchline. What can you do? Do a thought experiment before you file the patent application about what the key pieces of prior art are. You might know them through a search or your industry knowledge generally. And, think about whether a person of ordinary skill in the art would have had some reason to put them together. And think about what your response would be to an examiner who says that. Now, this can reveal some different things that can give you a good way to rebut an obviousness attack. This is a non-exhaustive list, but these are the big ones I encounter most frequently. Okay. The first one is, did you identify a problem that led you to put the elements of the claim together, a problem that nobody recognized in the prior art, and a problem that you solved because you identified it and solved it? That recognition of a problem is a good one that can help you overcome an obviousness rejection. And if you're aware of this, put it in your patent application, write that explanation in, build in your story of non-obviousness when you file the patent application. A second big one is, when you put these elements together in your claim, did you see something that you never would have expected from the individual pieces of prior art alone? This is often called evidence of unexpected results, or sometimes a synergistic effect. But if your whole is greater than the sum of the individual parts would have suggested, that's also a good basis for overcoming an obviousness attack. Now, sometimes this unexpected benefit can only be described qualitatively, and so you just build that explanation into your patent application. But sometimes you have a demonstrable improvement in some sort of numerical parameter, and you can actually generate data that shows non-obviousness. And if you can do that, it does pay to put it in your patent application when you file it. You don't have to in the United States. If you get an obviousness attack, you can supply that data, even though it's generated after your application was filed. You can supply it later and respond to the obviousness attack, but in many foreign countries you can't do that. They won't let you rely on data that's not in the application as filed, so you want to build that in ahead of time. And then the third big one is that, well, yeah, these individual elements are in the prior art, but there was a problem, a hurdle that I overcame in combining them. I'm the one who figured out how to combine them in the first place. And so if you are the one who overcame that hurdle, then that also may be a basis for overcoming an obviousness attack. So anyway, those are 3 of the big ones. I hope that helps to keep you out of trouble, and I hope to see you here soon.